All right, we are recording again. It's February 19th, 2025, 10:19 a.m. Continuing with Miss Bertrand's testimony. And I assume you want me to share the exhibits.
Sure. Thank you.
We had just finished with complainants 22. Are you going to complainants 23?
Sure. Yes, please. Thank you. I added the initial investigation into my report. I guess I could just testify in this, but I had added this because of comments or my point of view that I've written. No other zookeeper has been assigned to guest services. Guest services is a different job. Guest services under a different department in the zoo. It's under the operations department, or zookeepers are under the animal care department. The respondent said every zookeeper is expected to do the same work, but that's not true. We do all have the same job description, but we don't all do the same work. My coworker John Curton only worked in one area, herpetarium. We say areas as the larger areas like herpetarium, aviary, but he did work like the smaller areas, badger. But basically, just due to personal preference, he only had to work herpetarium for years. I do have schedules at the end of my exhibits to show the schedules as he only worked herpetarium. They also said that, again, speaking to essential functions, deliveries are all hands on deck type of situations, but that's not true. There's plenty of reasons why people are excused from deliveries if they just simply don't have enough time in their day. If they have, an animal veterinary procedure, they're not saying every single person that's at the zoo, every zookeeper at the zoo is, it's mandatory for them to show up for these deliveries. It's kind of most of us do if we have time in our day, but there's reasons even people have asked just because they weren't feeling well not to participate in the delivery. So, considering the delivery as an essential function and the reason why I couldn't be a zookeeper, I disagree with that because people are excused from those for a lot of reasons. They said it's crucial that zookeepers have versatility and that we should be moving around the zoo. And they relocated me because I only wanted to work in the aviary. I said that I felt comfortable working in green barn, herpetarium, aviary, and the smaller areas of the zoo that could be combined to make a bigger area. Porcupine was no heavy lifting. Penguins, badger, flamingo, and seals can or cannot be depending on the chores for the day, whether or not you have to lift salt. If you're not lifting salt, it could be a lighter area. In the schedule is showing Mary, she was in seals because we weren't lifting salt every single day. This discusses the administrative practice manual. It's a manager's discretion.
Page are you covering?
I'm still in the complaint or the response.
Mhm.
It's a long document, so we don't have to go through the entire document. I just added the response as an exhibit.
So you want that admitted, is what you're saying?
Yes.
Attorney Mullen.
So I'd just like to, I guess, maybe streamline this a little bit and make a standing objection to the hearsay and foundation issues that I've raised. If I have other objections to the exhibits as they're discussed, I will make them. But
All right.
if I may have that standing objection, I won't kind of reiterate the same hearsay and foundation problems every time.
All right. Yeah, we can do that. So, Ms. Bertrand, you know, my concern as I read it is these are your responses to the investigator's request for information. Is that correct?
Yes.
Right. So, we're here at the hearing. You're free to testify to any of that you want to testify to. But otherwise, the document is basically your testimony in a written form, right? And so, you're free to testify to that, but I don't necessarily need the document because then otherwise, what's the point of you testifying? So I am actually going to exclude this one.
Okay.
I will let you testify to any portions of it that you want to testify to get on the record.
Okay.
But you have to testify, and then Attorney Mullen gets a chance to obviously cross-examine you. And if we're not
Okay.
covering any of this stuff, then what exactly is she cross-examining?
Okay.
Right? Does she have to cross-examine the whole document? So any of the stuff in this document that you want to address, you're free to testify to.
Okay.
And then if there's documents that support it, you're free to reference it.
Okay.
But
I have a question.
I am going to exclude 23. Yes, go ahead.
Oh, okay. So when I initially received the response from the investigation, and then I contacted the DWD asking how this would proceed if I disputed it.
Right.
They said that we would go to the hearing, and that anything after this, since this case is dual filed with the EEOC, they said that my entire case gets sent to them. And so I guess that is why I included a lot of these documents, was because I thought that in this case, everything that I'm presenting into these exhibits is then going to be sent to them. If you don't hear in my favor. And so I guess that's why I don't know if I have to communicate with them and plead my case with them again. I thought that they were just going to read over this stuff and then have their own decision. So I apologize for the lengthy addition of all these exhibits. That was the reason for that. So is that incorrect?
So, you're free to try to bring in any relevant document that you think is appropriate. But
Okay.
in terms of this hearing, I'm controlling the hearing to determine what is relevant for your claim under the Wisconsin Fair Employment Act for the allegations you raised. And, it is a hearing. It's a clean slate. If it wasn't clear to you, I'm not sure what the investigator told you. It's a clean slate, which is why I
Okay.
think you're introducing some of these things, because nothing gets carried over automatically from the investigation to this phase. But my job is then to take in testimony, and at a hearing, it's typically verbal testimony. That's why we're here, as you can testify. The respondent can cross-examine you and your witnesses. You can cross-examine their witnesses, so that there's a fair opportunity for both sides. This document is your testimony. That's essentially what it is.
Mhm.
You're making statements about your case. Well, you're free to testify about that right now, and the
Okay.
respondent can cross-examine you. If I allow this to come in, then the respondent doesn't know what they're cross-examining you on, right? Unless you sit here and read it verbatim, which is
Okay.
also not preferred.
Okay.
So, you're free to testify to everything. So I cannot speak to what the EEOC is going to look at or not look at.
Okay.
If it's not in your favor and you take it over there, I suspect they're going to look at the written decision, which includes findings of fact, conclusions of law, and make their own determination. But that's them. That's not me. I can't advise you as to what's going to happen there.
Okay.
So for purposes of this record, it's going to be excluded. And then obviously for purposes of the state process, if I do rule against you or if I do rule in favor of you, whichever way, either party can appeal to Labor and Industry Review Commission. So there's avenues within the state level still. But anyway, that's beyond here. I'm not saying that this information can't come in. I'm saying if you want it in, you should be testifying. That's what we're here for. So that's why I said you don't necessarily have to just go C1, C2, C3. Feel free to state what you want to state, and you can pull in exhibits that support it.
Okay.
Right?
Thank you.
Yep. Or what would you like to do? You're free to testify to some of those things if you want to do so now. You can go on to other exhibits, however you want to do it.
Right, okay.
We're at 24, I think.
Yeah, I don't know what I. C24, but the ADA policy, I understand I was told I was not, covered under the ADA. It was went kind of back and forth as to whether or not I should be, but I wanted to include the policy because I I thought that they had to find undue hardship in order to deny me employee accommodations.
So I object to this. Like this is at least in the documents I got, it's just a link. And it's also completely irrelevant as this is not an ADA claim.
So we had addressed this at the final pre-hearing. There were a number of documents that were only a link, and then Ms. Bertrand was to submit them, send them to Attorney Mullen and to me. Did you send them to Attorney Mullen, Ms. Bertrand, copies of C 24, 25, 26, and 34?
I thought that I did.
Attorney Mullen, do you recall?
I don't know. I assumed that everything was sent and that because then you had Judge Fermin, that you had then had the numbers applied to once all of the exhibits were in like a printed form. But
right,
unless I'm missing something, like on this one, I don't see them all. I don't see the entire document. I just see the link. So
after the link, I did have the support staff leave the page with the link, and then right after the link, so starting at ERD 106, I believe is what she's referencing, 106 to...
Oh, I'm sorry. I think it might be duplicated.
To 113.
Okay. I believe part of the confusion is it was in here twice, without once with the pages and once with. Yeah, anyway, my objection
is possible. The support staff had to add it in because there was issues with formatting. So anyway,
no problem. I do see it in the document, and I still object on the grounds that this is completely irrelevant to this case because it is not and it's not an ADA case.
Right, and Ms. Bertrand, it is not an ADA case. I know you say that you think it should be covered under the ADA, but for state purposes, we're dealing with the Wisconsin Fair Employment Act. So unless you feel like this policy also addresses anything under the WFEA, then I'm happy to hear it. Otherwise, I also don't see the significance of it for this purpose.
Okay.
Again, if you think it addresses also WFEA, then you can let me know. But otherwise,
I added it because it kind of discusses what an interactive process looks like, but yeah, you are correct that it is ADA. So if you don't want to add it, that's fine. I'm okay with that.
yeah, I mean, it's not going to be relevant, so I will say we can exclude it.
Yes, we can exclude DFG at this. Right, you're
Okay, exhibit number 25, the H3C final report. So due to, allegations of racism, by zoo management, allegations of retaliation for union activity, retaliation for whistleblowing, unequally disciplined, allegations of unequally disciplined, staff members. The county paid for an external investigation to take place. This was happening during the time that I was pregnant. We had two black zookeepers left the zoo, stating the reasons they were leaving. Part of that reasoning was for discrimination. And then this also discusses the staff's fear of retaliation from the zoo. So as I had stated earlier, when I had been removed from all animal duties, I contacted the board. The board contacted Judge Bailey Wren. She's the one that wrote this, that was doing our investigation, and she's the one that discussed or helped me to get some animal related tasks.
Okay, are you trying to move this in as an exhibit?
Yes, I'd like to move this in for an exhibit. It does talk about, let's see.
so
It talks about the zookeeper being removed from Big Cats, as retaliation. So that is like, one of my statements says, the management will punish zookeepers by removing them from working with the animals that they are most bonded to. This discusses that. Marley Man being removed from Big Cats also discusses a zookeeper being removed from the giraffe barn, which was her primary area.
okay, what page was that on?
That is on, well, that was just in the timetable right here.
On where is it though? Page 12 of
Yeah.
the document.
Yeah.
Yeah, in Susan's testimony earlier, she had discussed how how she feels the unequal treatment she received during her pregnancy was also a result of her bringing HR in to try to help resolve another issue. which this document shows several other employees had the same issue with management at the zoo.
I object to relevance. I don't know what issues are being discussed at all.
So it's establishing that management has treated other employees or has used removing people from their preferred jobs as a form of retaliation or punishment for things when they tried to tried to get accommodations in the past. And this is part of Susan's testimony as to what happened to her.
I have already made objection to the fact that this isn't a retaliation case. And I'm not sure, well, what has been described has nothing to do with her pregnancy.
Yeah, I think I'm struggling to connect the dots. I mean, I guess you're trying to show that there's a history of bad acts. I'm assuming is what you're trying to do.
Yes.
And I don't know that that's necessarily going to be relevant to this case. There's a lot that can be distinguished, and I haven't gone through it to even see, what's there, right? And I'm not even sure if it's necessarily my job to go through that. But are these actually the same decision makers or the same situation? It sounds like this is not dealing with pregnancy. I understand you're saying it concerns people requesting accommodations or getting HR involved and then having these things happen. But generally speaking, we don't consider prior bad acts.
Okay.
I mean, you're obviously things that happen to you, you can testify to and hopefully show. And that's what's going to be relevant versus what might have happened to other people in the past. So unless there's something else that you feel like this is going to more concretely tie into your claims, I'm going to tend to agree that it's not going to be relevant.
Okay. Yeah, I was just trying to show that I was concerned that they would remove me from animal areas because that is something that they've done in the past. And rather than asking for people to be here as witnesses today, and I thought that this would show their case, saying that they had been removed from animal areas as punishment. It also discusses favoritism and between job assignments and just the overall staff, work environment, and also discusses, which I have later on in the exhibits, I believe, so you can, the zoo's organizational chart as to the findings of this document show that it is believed that Elizabeth Peterson does show favoritism and that the judge recommended that she not be in charge of discipline, and Beth was the person who was making decisions as to what my job assignment was going to be. So I thought it might be relevant.
I object completely to the foundation for any of those statements.
Yeah, where in the document are you claiming that it states that? I guess we could start there.
The flow chart, or let's see, it was in, here. That is in the appendices.
Exhibit
I think
26.
it's final thoughts. I'm sorry, this will just take me a moment to find where they. talk about Beth. Let me see here. That might be.
Do a search.
Okay, so sorry. Well, I also saw it talking about safety concerns. I apologize for the delay. No, it's gonna do the whole thing. Shoot. Okay.
Okay, it's not in the.
Sorry, we're unable to, we were trying to search for the keyword and we're not able to do that.
Mhm.
It's at the bottom. Oh yeah, here. Oh no, that's.
All right. Well, so
I
first
apologize.
I want to address that, you're making statements about witnesses not being present, but
Okay.
it's making me assume that the beard retaliation, right? There's been no showing that you try to get witnesses. There were, for example, no subpoenas that were requested.
Okay.
So to the extent that you feel like there's evidence that could be presented with witnesses that aren't here, I mean, there's really nothing I can do about that. If they're not here to present testimony, they're not here to present testimony.
Okay.
And just you kind of saying, well, fear retaliation is not going to be a sufficient reason. I mean, is it possible? Maybe it's possible, but that's, for me, that would be speculation on my part. So I can't, do anything with that. What am I supposed to do? There was no attempt at even having, when is this identified other than the one that you have later. So that's the one thing. And then the second thing is, yeah, it doesn't sound like this document clearly states what your testimony was saying.
Okay.
And then looking at the scope of it, I agree that it's not relevant, and I am going to exclude C25. Are you attempting to address C26?
I'm yeah, we're just discussing if the following is going to have the same result as it's the appendices from the same discussion that just shows that the same, there's this was, just a report on the environment. And it does go on to say that safety issues aren't addressed or taken seriously. And also talks about the retaliation, and so it would likely have the same.
Yeah, I mean, I guess I don't see what the connection is to
Okay.
the discrimination that you experienced
Okay.
based on your sex or pregnancy.
Okay. So then we get to,
27.
that's why that was confusing. Okay, that's just the response. And like you said, I can give testimony for that. Just wondering why I was seeing a lot of the same documents.
Oh, the 26 is excluded in case it wasn't clear
Yeah.
for the record.
Yeah, that was clear.
Are you moving to C27?
Yes, that was, again, I added that for the same reason as I added the other investigation because I thought I needed to add all this stuff into here. So this was my response to their and to the respondent.
Are you still trying to have it
I'm
admitted?
Liz.
Judge Furman, there's just there is a lot of this document is Susan's testimony, which would fall into the same problem as the previous testimony that she had written here, but there are sections of this that she wants to reference as part of her testimony here today. Can she take 5 minutes to take a look through it? And
Are you going to be testifying to it right now? Is that what your intention is? Or are you intending to go through these documents and then
Let's
adding
see.
in testimony?
I guess I just wanted to, like you said, I was kind of hyper focused on reading all of the exhibits, and I just wanted to make sure if we're going to exclude these testimonial pieces that I've added, that I am making sure to then state this to you. So I'm giving you my testimony. So I can just go through it and we can discuss it, and then at least I'm stating it, and I'll let you decide on after that if you would prefer to do it that way.
Well, Attorney Mullen, I'll let you respond first.
Yeah, I mean, I object to this document as being like, I mean, it's a very broad in scope. These are discovery responses. It's cumulative from what I could tell reviewing the document. Many of the pages of this document correspond to exhibits that have already been discussed or are likely to be discussed. I guess like on those grounds, I would ask that that this document not be admitted.
Yeah, so as you know, Ms. Bertrand, it is the same issue as before. And then typically the concern is with trying to review the document. I guess I'm unclear as to why you can't just testify to it.
Okay, that's fine. I just want to
what
make
you-
sure that I just didn't want to leave you waiting, but I will just look over it and just try to give my testimony instead of reading it. I guess I can, yeah. We can just skip over this for now, and I will move on to the
28.
oops. Sorry, I'm just looking for the correct page here.
It's 200.
Okay, thank you.
Yep.
So you are going to see 28.
Yes, is that the next one? Okay, yes.
So for the record, are we not admitting 27?
Correct.
Thank you. Okay, this is Brian Wilson and Ravella Sue. I sent an email asking about light duty work. Said he's worked for Dane County for light duty restrictions for over the years. Back in 1995, when I was a zookeeper, I had a hand injury to my left hand. This is just showing that he has had, he's been allowed to maintain work as a zookeeper and a maintenance person, with restrictions from personal injuries and work-related injuries. That's C28. Just an example of showing that other people have, the next few exhibits will just be examples of showing other zookeepers and members of the animal life support team that have been allowed to continue in their job duties.
So I'm going to object to all, like, well, we haven't gotten to the other ones, but to this one, at least for now, because this person is not a witness. I don't have an opportunity to cross-examine this witness to discover whether these situations are in fact parallel to Ms. Bertrand's or not. So, you know, this is an entirely a hearsay statement that should not be admitted for the truth of any matters asserted.